and start our conference committee between House and Senate Judiciary. Welcome, and we're just going to get right to it. We have several things that we have planned to do this morning, and just for information's sake, this room will be occupied at noon by a different group. So that's when we will plan to adjourn. So the first thing we're going to do is we're going to take House Bill 2070, which is now Shell, and the conferees were changed so that it's now Senate conferees. And we would like to put in House Bill 2510. Natalie, can you tell us about that?
Sure. Thank you, Madam Chair. And I think research brought copies of the bill for you all to look at. House Bill 2510 is the bill related to third-party funding litigation. The House made some substantial amendments to it in committee. They passed it across their floor, sent it to the Senate, and the Senate had an informational hearing on it toward the end of your committee schedule. And if you have any specific questions, I can take those.
So our offer would be to take the contents of House Bill 2510 and put them into House Bill 2070.
Thank you. Question for the reviser. So 2070 is an empty shell at this point, so we can procedurally, that's appropriate.
So, Madam Chair, you would kind of remove the contents. It's not necessarily an empty shell, but the conferees are the 6 of you here, so you can do whatever you want with it. And so you can remove the contents of 2070 and place these contents in there if that's your wishes.
And then more of a substantive question for the reviser, that the subject matter of the bill is familiar to the Senate Judiciary Committee. We've heard it a couple of times. And so are there some significant differences? I'm thinking it's the bold part, but if we could have a little bit of information on that. And that would have been also part of the informational briefing that we had in Senate Judiciary just a couple weeks ago.
Okay.
I'm correct.
Yeah. Thank you.
That would be great.
Does. Would you like to just give a little bit of an overview, Natalie, if you don't mind, especially the changes? Or, okay.
Sure. Thank you, Madam Chair. And by way of background, actually, the Senate had a bill related to this topic last year. And you guys heard that bill. You did a little bit of working on it. And then the subject matter was introduced in a House bill this year. And so you guys heard that bill and you did a pretty substantial amount of work to it. And, to Senator Warren's point, the parts in bold are the new parts. So I believe our office probably did a bill brief on that. So we can get copies of it.
And that's all right. In the interest of time, the Senate Judiciary Committee is familiar with it. I think there's a reporting requirement to the Kansas Judicial Council, and then some definition added about foreign person. And so it's in the bill 2510. And where did those proposed amendments, or where did the amendments that have this passed the House, right?
Yeah. So this passed the House, and the way it was first introduced, there was some neutral testimony, but it actually was it kind of sounded like opponent testimony, especially from the Attorney General, feeling like there were not protections in there to protect some possibly nonprofits. And so we added some limitations as far as protecting the nonprofits. And then we also felt like it was a good protection to add the reporting. And the reporting that was okay through the Judicial Council, that they were okay taking on some of that reporting, and then they would give a report back to us. And then also just the definitions seemed like it was clarifying. So that's where the amendments came.
Thank you. From the Senate side, are there any other questions either for the reviser or for the chair? I'm not seeing any. So let us confer for a moment.
Okay, thank you.
Thank you, Madam Chair. We've got on the Senate position, we've got 2 in agreement and we've got 1 disagrees. So we will probably need an agree to disagree.
And I'd just like to ask the House members if, go ahead.
Yes, I support the bill,
Thank you, Madam Chair. I would vote against this motion. Thank you.
So it seems like we have in this case an agree to disagree about this bill. If you all could prepare that report.
Thank you.
Thanks, Madam Chair. So I've had a number of concerns with this bill over a number of years. So I think this is probably the first year that House Judiciary has heard this. Correct me if I'm wrong, but we've heard this in Senate Judiciary for now. This will be, we've had two full hearings and then 1 informational hearing. And I think actually a majority of our committee is actually with me and saying that they don't want to see this move forward. That's why for 3 years now it has not passed the Senate Judiciary Committee, because the majority of our members have concerns. And some of those concerns, so going back, so the first year that we heard the bill, we voted on it. My recollection is it failed to pass the Senate Judiciary Committee. The second year we didn't vote on it. I feel like presumably because it still didn't have support of the members of the Senate Judiciary Committee. And this year we just had an informational hearing on it. So I don't think any of the members of the committee have necessarily changed their views on the substance of the bill. I actually think this is probably the worst version of the 3 versions that we've heard. I think this is actually more problematic than any of the 3. This would be one of the most extreme versions of third-party finance disclosure of any bill in the country. And I think it's really troubling because I've asked now for 3 years for actual evidence that this is a problem in our Kansas courts. And none of the proponents have ever provided me any evidence that this is a problem that is impacting us here in Kansas. Really, this is an issue for these big multi-district litigations, class actions, big patent cases, things of that nature. This is just not an activity that is happening in our Kansas courts. So I don't support making laws for something that frankly is just not a problem in our courts. The second challenge is I think it does unnecessarily burden plaintiffs, because you have an issue where the plaintiffs have to provide this information, and really there's no benefit. There's no real tangible benefit to this other than giving the defendants kind of a sneak peek into the resources that a plaintiff may or may not have. And what's come up is that, well, insurance agreements are discoverable, but that's really not apples to apples, because in an insurance case, the insurance company is actually running and managing and providing the defense. Whereas here, the third party litigation funding is really all just passive. It's all just passive investment. And so they're not really controlling, or they're not responsible for the litigation. Going more specifically into this bill, I think it's problematic because if you look on page 2, and I think this came from the Attorney General at the bottom, if you look at lines 29 through 43, it talks about the prohibitions of when a court can prohibit inquiry into the existence or non-existence of a third-party agreement. It says the court shall consider the political, ideological, or social nature of the case. I find that to be immensely problematic. Usually we want courts to specifically not take those things into consideration. So the fact that we would be asking probably a state district court judge to consider the political, ideological, or social nature of the case, I find that to be just immensely troubling. That kind of turns the whole proposition of having a judge on its head. Additionally, third-party agreements are currently already discoverable. I mean, I'm looking here in Section 1. If you look at Section 1, lines 19 through 23, it says, unless otherwise limited by court order, the scope of discovery is as follows. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. So if a party can currently today go in and say that there's some reason why they need to have access to this agreement, and a judge can make a decision. Judges make decisions similar to this every day in courts all across our state about whether or not it's material to the case. That's how discovery works. So again, don't see the need for a bill specific to these agreements. The other thing is, I think we're really getting into issues around just the general freedom to contract. Right. So these agreements, if you think about it, between plaintiffs and a third party funder, they are arm's length transactions that are negotiated between two private parties. So you have two non-governmental actors making a decision, and they both reach an agreement that they believe is mutually beneficial. So since when have we as a state ever said that we are going to interfere in the freedom to contract? And specifically under this talks about reporting and disclosure of these agreements to a governmental entity. So the Kansas Judicial Council then is going to have a contractual, so you're going to have to turn over these agreements to the Judicial Council. So we're going to start turning over privately negotiated contracts to a government entity. I don't know how we're going to maintain disclosure and confidentiality and things of that nature. I mean, to my knowledge, this would be the first time anywhere that we would kind of mandate that disclosure. And that would be regardless. The way I read this, it'd be regardless of even if a judge says you don't have to disclose it. So that to me is problematic. So again, I think I'm with a majority of the Senate Judiciary Committee and being very strongly opposed to this. So thank you for that.
As chair of Senate Judiciary Committee, I need to correct a few things that have just been stated. There is no evidence that a majority of the Senate Judiciary Committee does not support this piece of legislation. So that is not an accurate reflection of the majority of the committee. And so we need to be clear that we don't know what the majority of the committee is, because as a matter of fact, I don't believe that this has failed in Senate Judiciary Committee. So if representations were made otherwise, that would not be accurate. The reason that there are probably the third version is because opponents of the bill have not been willing to come to the table and put together a package that could become law. It has passed one of the chambers, it has passed the House, and so that's where we are.
Thank you very much. Senator Corson said a lot of the things that I wish to say as well. Generally, when I vote in favor of a bill, I go through at least to start with a two-part test. Number one, has there been a determination of harm within the status quo? And number two, does this bill solve for that harm? And for what is currently House Bill 2510 and what will be 2070, I think that it fails on both of those merits. I don't see that the proponents propose that there was a harm to the status quo that needs solving. And their harm itself is that these third-party litigation, these third-party funders unduly influence the bill itself, or the litigation itself. Sorry, thank you. That is not being solved in this case. There is number one, no evidence that that is even occurring. And number two, there's been no evidence that shows, or no proposal that shows that anything in what is currently 2510 would solve for that problem. Secondly, when we talk about sending this information to the Judicial Council, the problem is that we're putting the cart before the horse. Unlike, say, with civil asset forfeiture, where we have current law, we're trying to determine, is current law effective? And we send that information out and we ask for the Judicial Council's review on that. Or for other things, we're looking at current law. What we're doing in this case is saying, we wish to change current law and then figure out, is this a good idea? That is backwards. And for both of those reasons, I can't support this bill. Thank you.
Thank you, Madam Chair. So I think it's important that we step back and kind of look at the impetus for the bill. which hasn't been yet mentioned. I'm sure it was in the hearings, but this is a huge industry. I believe in 2020, it's estimated that $2.3 billion was invested in litigations around the country. And there's nothing necessarily inherently wrong with that. The problem is that it's all opaque. We don't know what's really happening with these third-party funders, to what extent they're controlling the litigation or not. There's a principal agent issue here. Typically in litigation, the principal, which is the client, the plaintiff, controls the litigation, and the agent, the lawyer, is the agent. But there's been some cases that have been publicized in the press where it looks like the third party funders have become the principal and are controlling the principal, even though they're the agent. The other thing is that the funders, unlike lawyers, are not subject to ethical restrictions on how they handle and interface with the plaintiffs. And then finally, the other concern about what's really happening here is litigation terrorism. We all know that China and other adverse countries are using every tool in their toolbox to undermine our democracy, to undermine our country, and to strategically undermine our society. And we know that they have and continue to try to interfere with our elections. There's no reason to think that this is not an avenue that they will look to undermine what's going on in our democracy. I also want to address the point that this is an extreme bill. I just disagree completely. My understanding is that the other few states that have enacted something along these lines are much more invasive. Some have prohibited the funding in certain circumstances. It's important to realize that this bill in no way prohibits third-party funding. The way it works is the defendant can request information about the agreement from the plaintiff, and if the plaintiff says no, then the court gets involved and takes a look at the various factors that are set forth in deciding whether or not there should be disclosure. And so there's first of all, there's no necessary disclosure under this bill. And secondly, it doesn't prohibit the funding. I can imagine a circumstance where the court would require disclosure and look and see what's really happening and raise some concerns, and may say that this isn't the way things should work. But in and of itself, this is no prohibition. It's simply a transparency bill. And then as far as the reporting goes to the Judicial Council, this is one of the provisions that I think is best, because the Judicial Council will receive information about to what extent this is going on in Kansas. It may be not going on at all, but anyhow, they're going to be looking at it. And the other aspect of the reporting is that when there's a third-party funding agreement in a Kansas litigation, the party has to also report whether there is a foreign entity involved. All of this is in order to give the Judicial Council information on which they can then give us a report in a few years. I think it's 2029, about what's going on. And at that point, the legislature will have an opportunity to look at things. Let's see. Oh, there was a suggestion made that this third-party funding is passive. That I've already addressed that. That may be the case, but we really don't know because it's so opaque. It should be passive, but the concern is that in some instances it's not passive. That where you have a funder putting hundreds of millions of dollars into litigation, at some point they take over that litigation, and the plaintiff is just a straw man effectively, and that shouldn't happen. And with that, I'll yield the floor.
Thank you, Representative. Ditto. I think that's why we think this is a good bill. I do want to address just a couple things too that were said earlier. One of them is that the Senate has heard this bill 3 times. You've heard a version of this bill, but the point is the one that was introduced in the House this year is a transparency bill. As the representative previously said, I think the ones you heard before, if I'm not mistaken, were much more stringent and may have even required no third party funding for litigation. And so this one is really a transparency piece. And the Judicial Council is a big part of that. And of course, none of this is admissible in court, but also the reporting to the Judicial Council is not susceptible to our core laws. They're not going to be open records. And the provision also has a sunset. And so it really is to get information to find out, is this going on in Kansas? So I appreciate the word opaque and I appreciate the word transparency. And that's what we're trying to do here with this bill. Thank you.
Just one thing I forgot to add. It was stated that under current law, these kind of agreements are discoverable. I disagree with that. The provision that the representative read has to do with the fact that you can get discovery of relevant information. Relevant is defined as something that would be lead to the admissibility of evidence at a trial, and that misses the point of this bill. It's not about getting relevant information. It's about ensuring that the litigation process is proceeding as it should, taking care of the problems I mentioned, which were the principal agent problem, the concern about foreign interference in our litigation, and attacking strategic industries, whether it's aerospace or ag. Thank you.
Okay, so I think you've heard our offer, and then it appears that we've come to a conclusion of an agree to disagree.
Thank you, Madam Chair. Right. I don't know the proper procedure, but I think this is just a motion to move it in. I don't know if there needs to be a motion to or an agree to disagree on a motion, but maybe the revisers might be able to.
So maybe the House needs to make an offer and the Senate can accept it or not. We already did. Right. Unless he has been so persuaded by okay. And no over there either. So and agree to disagree then.
Oh, did you want to say that? Okay, so I think we have 7 bills in conference, and so I kind of went down. Yes. Mm-hmm.
I apologize. This is kind of a question for the revisers. I was looking at kind of our GO and what's below the line. So I saw that there were 5 different House passed bills that were referred to Senate Judiciary that are below the line on the Senate GO. And they're not on this sheet. And I was just kind of a question for the reviser about, wouldn't those also be conferenceable? I had 2487, 2601, 2741, 2069, and 2293. Those may not all be with House Judiciary, but they were all House passed bills that were sent to Senate Judiciary and are currently below the line. So my understanding is all of those would be conferenceable should a conference committee wish to discuss them. Am I correct about that? Because I'm just wondering why they weren't on this sheet, because they're with another committee, another House committee.
So conferenceable and being in conference are 2 different things. So bills in conference, for instance, have passed both houses. And so, but we have a disagreement on the language in that number. Like, for instance, Senate Bill 500, we have in conference. We have two different languages in Senate Bill 500. So we come to conference committee to hash out those two. Any language that has been passed by one chamber or the other is conferenceable and can be put into a number that is in conference. So I think that's the difference. And if you need to correct me, please go ahead.
I was going to say, that sounds good to me.
No correction to the conferenceable statement. I'll just say our chart, this chart is only items in conference. I won't put anything on this chart that has not been non-concurred by one chamber or the other.
And you would need a conference committee appointed to a bill for it to be in conference. And those are the ones that we have on the chart.
Our general rule is once one side is non-concurred, we'll put it on this chart because then we're waiting for an accede. And if that never comes, it's not in conference. But once it's non-concurred and acceded to, it's definitely on the chart. That's all that's here. Everything else is the universe of conferenceable bills is beyond our scope.
So with that, I know that it's almost noon and the room is needed. And
Yep. And so we'll just continue on. We are wondering about continuing on if the House adjourns. We're supposed to be back on the floor at 12:30. So if we were to adjourn at, say, 1:15, could we come back, or what is your schedule?
are we back on the Senate floor at 2? We are back on at 2. And I believe you meaning you're recessing
I'm sorry.
during the
I
day.
keep saying the word.
So
Everyone, please forgive me. I keep saying adjourn and I mean recess. Yes.
it's okay. It's unusual for the chambers to recess rather than adjourn. So you are back on at 12:30. We are back on the floor at 2. And we do have some other business with other committees that we need to wrap up. So let me circle back with them.
Okay.
So I can't commit our side to anything at this minute.
Okay. If available, if I could, I could announce it as we're recessing for that second time, then that would be great. And then, okay.
We need folks to watch the website and emails as well, because sometimes we're not able to announce conference committee meetings on the floor, but we do schedule them with emails or website. We do that for sure. Yes. So,
okay. Yes. Thank you, everybody.